Recording. Okay, we've just been talking about the exam, and I've been saying all we've really got to is we have said we have one big set of facts, and there is problem facts that run for question 1 and question 2. Question 1 is worth 17 marks. There's a big IRAC. Question 2 is split up into 2 smaller things, and the first part of question 1B in section 1 is worth 6 marks. That's the baby IRAC that you need to do, and question 1B sub 2 is only worth 2 marks. And that 2-mark question is just drawn from the damages issue that's discussed in the Wilson article online. Then we started to discuss the large IRAC that we need to cover off for question 1A. That's the 17 marker. And we've just been playing around with how people might put the rules down in the rules section. And I've said that there is absolutely no need to copy out the text of the relevant pieces of the legislation. As I said before, you can just, for example, where you're going to refer to section 4 sub 2, which is of the CCA, referring to acts done and silence. I've just gone section 4 sub 2 refraining to acts dash silence. Okay. I don't need you to give me a great long rules section. For application, and this is really the gist of the guidance that I wanted to provide to you this evening. In the Hinton case, they tend to discuss the issue of the conduct itself first, okay? So I would suggest that you do a little heading saying something like, conduct at issue, and is it covered under the ACL or something like that, okay? And that gives you a good opener to then discuss for me with the threshold question of whether or not this conduct's even going to be covered under the ACL. That's your logical, first threshold question. Because unless this silence at issue here is covered by the ACL, there's no point in doing any further analysis, is there? So first cab off the rank, I would like you to discuss for me the conduct at issue, okay? And the relevant legislation and any relevant cases that you feel required to be discussed in relation to the conduct at issue, okay? Then I would suggest the other chunk of your answer should be devoted to discussing was the conduct misleading? Okay, was the conduct misleading? And obviously that is you've got to look at then the various different requirements of section 18, don't you? All right. So you're going through those various different, what does section 18 say? A corporation must not, in trade or commerce, engage in conduct that is misleading or deceptive or likely to mislead or deceive. So you need to give a tick to those, those threshold questions, and then you ultimately arrive at the question of whether the conduct was misleading. And there, as I said, you've obviously got that umbrella test, and where you have silence, there are other factors that come into play. So you will be needing to discuss the other factors that come into play there. Obviously, also, you will need to be discussing the Hinton case. At the end of your question, you will need to conclude for me what remedy will follow. For question 2, so just to recap on that, for question 1 sub A, it's worth 17 marks. And for your application section, please give me two headings. Firstly, what is the conduct at issue? And is it covered under the ACL? And second, was the conduct misleading under section 18? Okay, so for question 1 sub B little 1, as I said, 6 marks. You need to do a baby IRAC here. Now, for this question, I've added on a few extra facts to the main facts. So I've given you a few extra sentences of facts there that just change things a little bit. And then I say, in light of these further facts, you know, what's the case? All right. For question 1 sub B sub 1, which is your 6-mark baby IRAC, you need to assume that the conduct was misleading. I don't want a repeat of all the stuff you've told me, all of the relevant legislation and case law and tests and all that stuff that you need to go through in question 1A. There's no need to go through any of that in question 1B little 1, which is your baby IRAC 6-marker. Okay. I've cut short all of that, and the question is in relation to claiming losses. All right. As I said, question 1 sub B sub 2 is just that little 2-mark question, also in relation to claiming losses. Alrighty. For section 2, it's pretty much as I advised things would roll last night. So section 2 is a total of 15 marks. There are 3 questions, each of 5 marks. You do not need to do an IRAC for any of these questions. Okay. The first one, as I advised last night, so section 2, question 2, sub A, it also draws from the main problem facts, and it is in relation to discharge by agreement. In relation to, so we can just use ACL instead of Schedule 2, blah, 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 blah. Yes. Sorry, Angelina, I hadn't picked up on that. Yes. So similar to how a judgment is set out. Absolutely, yes. So you'll see, if you take the Hinton case as a good clue, your structure will be fine. But in any event, as I said last night, the Hinton case really is just, there is no magic about the Hinton case. In fact, the actual decision is not on the legislation that we're looking at, but it fiddles about with all of the same principles. So, as I said last night, there's no magic to it. It wouldn't really even matter if you didn't look at the thing terribly much, because it's just an exposition of all the principles that surround the issue of silence that we've discussed, drawing from the text. Okay. But I think it's quite nice because they do refer to some recent authority that the text refers to. So 2A is about discharge by agreement. 5 marks, no IRAC. Question 2B, as I said last night, is in relation to frustration. 5 marks, no IRAC. Question 2C is in relation to, as I said last night, losses claimable under the ACL. Losses claimable. And on that issue, you need to discuss there is an issue of breaking off negotiations and with another potentially valuable contract, and we've discussed that issue previously in the Zooms. So you should feel comfortable with, the difference between how you go about seeking damages under the ACL and what measure of damage is used under the ACL, and the very different nature of how you go about seeking damages, for breach of contract. Okay, so question 2 sub C deals with, the measure of damages under the ACL. Again, that's 5 marks, no IRAC. Okay. Section 3, total of 10 marks. Okay, total of 10 marks. Now, as I said last night, these are a smattering of 2 and 1 mark questions. No IRACs for any of these, obviously. And they're pretty much as I anticipated last night. So you've got things like, there's a cluster of questions in relation to damages. So as I said, you're looking at things like mental distress. You're looking at things like the difference between, damages in contract and tort. You're looking at things like remoteness. You're looking at things like other heads of damage that you might get. You are looking at issues of defective performance, and so you need to look at things like entire contracts. What's an entire contract? What's a divisible contract? What is performance? What is acceptable for performance, not acceptable performance? And as I said, get your head around FOB contracts. Okay.
Can you hear me, Adrian?
Yes.
Sorry, I've just dropped in and out about 5 or 6 times, so I'd missed that last bit, but I'm sure it's recorded.
It's recorded now.
Yes. For some reason, my internet went unstable, but I just wanted to ask you quickly before it goes again. Today when I checked the release time for the exam, it told me 5 p.m, but I saw that on the Facebook you said 9 a.m.
Yeah, it'll be 9 a.m.
Oh, so it is 9 a.m. on Friday?
Yeah.
Okay. And so, sorry, what time do we have to hand it in then?
5 p.m. on Monday.
5 p.m. Monday. Okay.
Yeah. I shouldn't really do that. But, I'm aware that there are people that work on weekends. There's people that work during the week, and it's really hard. They're actually trying to get us to do much more of the, the 1 day or 48-hour things, but not this term. So we've managed to get it a little bit longer for you. Don't rely on that next term. We may be operating differently. So yeah, 9 a.m. and then I'm going to give you an hour to look at the paper, and if you have any questions or queries about the paper, then I've got the Zoom from 10 until 11, so you can get some immediate feedback if you're really worried about, not understanding a question properly or something like that. I'll be available in the Zoom room from 10 until 11. Queensland time, yes. And we can get any problems sorted out, on the spot. And then any other written queries, I'll be available until 9 o'clock that night. Is there any? Okay. Yep, no worries. Any further questions? That comment from Simon is actually a really good idea, and I have suggested it in previous terms. When I used to run corporations law, I'd say, look, you understand where I'm headed with the requirements for the major IRAC. I've told you where to go looking for the legislation, case law, so forth. So you can probably start fleshing out an IRAC, even now, and then match it up, obviously, with the facts when you get them. Just make sure in that big IRAC that you do cover off the issue of, what was the conduct and is it covered? And then the separate issue of all of the requirements of misleading conduct under Section 18. Am I teaching in SEM 3? Oh, no, Ilonka, I missed out. I do love corporations law. I hope you enjoy it. Yeah, I know, right? It's a really fun subject. There's loads of awesome cases, not as many awesome cases as contract, but there are so many naughty director cases. It's really, the naughty director cases are actually quite fun. Any other queries? I'm mindful that people may have to skip off.
Yeah. Are you doing equity next term?
Equity? No, I'm not. I believe that a new lady by the name of Dr. McEwen may be taking equity next term.
Okay.
But I'm not 100% sure. I'm not 100% sure. I'm actually off researching next term, and then I'll be back for contract A and contract B next year, and also intellectual property law in term 3, I think it is, and an honours unit as well. Yeah, do honours. You're bailing. Okay, yeah. If you've got to go to torts, if you want to have some dinner, any idea who does corps next term? Yeah. Is torts on? Oh, you're bailing from corporations. Corporations is I actually think it's a pretty good unit. The unit that I found most challenging was evidence. Torts isn't on. Oh, you don't have torts tonight? Oh, is it just revision for you?
Anna's in the US.
Las Vegas.
Oh, okay. So are you getting a heads up on the exam stuff?
We hope so.
Okay. All right. Well, anyway, you've got more than enough stuff to go on with for contract. So hopefully you'll be feeling good by the end of the week. I look forward to seeing those of you that have arranged a last minute Zoom with me. There's a few on Thursday. But other than that, go forth and conquer. I look forward to reading all of your wonderful IRACs.
Thanks, AJ.
No worries. I'll see you Friday if you can make it.
Yeah, well do.
Thanks. See ya.
See you, everyone.
Thank you. You go on.
I'll stay for a minute in case anybody needs to ask me some last minute questions.
All good.
You're all good? Hey, Morgan.
Say last night that there was going to be something on there regarding Future Matters, Section 18 and Future Matters.
Yes.
Is that? I didn't hear
Yes.
it tonight. Is it on?
Yes, it is a representation about future matters. It cuts into question 1 sub B.
Okay. And then I had a question. I'm not sure if it relates, but I was confused. Something in the textbook, I think I was just a little bit dazed and I didn't understand. But it was talking about the onus in future matters, I think.
Oh, actually, let me see. Representation as future matters. Let me just consult my answer guide. No, because the way that I've now drafted 1 sub B sub 1 is that you are going to assume that the statements were misleading.
Okay.
So that you don't have to go through, and those were the statements in relation to future matters.
Yeah.
But you don't really need to go through all of that again, because otherwise you're going to have to go through, all of that other stuff.
Yeah.
Was it a corporation? Was it in trade or commerce? Was the conduct misleading?
Yeah.
You're going to have to go through all of that stuff. And it's just going to be duplication. So that's why I redrafted it. So, yeah, strike that comment from the record. You won't need to go through an analysis of future matters.
Oh, cool. Just for future reference, I think I was confused about accessorial liability and what the evidentiary onus is for that in regards to future matters. From what I was reading in the text, it switched. Is something was different?
It's switched. I think
The onus was reversed or something?
there was some confusion about whether or not the onus is reversed, and on my understanding, the onus is not formally reversed. There's some discussion about it in the text, and it goes through and says, well, no, because if you can adduce evidence, then the court just takes all of the matters in context, and they don't, there's no evidentiary assistance given to the plaintiff.
Yeah, okay.
I wouldn't get too hung up on presumptions and whatnot anyway, purely because, and we discussed this a little bit when we were talking about undue influence, a lot of the presumptions that you run up against in contract law are not real presumptions anyway, as you learn about them in evidence.
Yeah.
They're not actually formal presumptions. You'll find that there's some evidentiary presumptions that crop up, and this is one of them. So the legislation just basically sets it up that if you do make a statement, then you're going to be taken not to have reasonable grounds unless you put evidence in to show you reasonable grounds.
Yeah.
So what it really does, I think, is it just gives the defendant a nudge to place, if they think that, you know, this is going to be an issue, to place evidence on the record so that their reasonable grounds can be considered by the court.
Yeah.
There is a bit of soul searching that goes on around that kind of stuff, but at the moment, the way that 1B is drafted, you can assume that the representation was misleading anyway. So one less thing to have to worry about.
We've got that question. Thank you.
Okay. Anything else?
That's all I have at the moment, but I'll email you if I need to jump in on a Zoom maybe. Yeah.
Okay.
Thank you so much.
Go and have some dinner.